All right, good day, everyone. My name is Fadi and I'm talking to you from Nearton Associates and Visa Place. I am a U.S. attorney, I'm also the managing director here. I am joined by Danielle Gerbic, who is a senior manager with the U.S. Processing team, and she brings forth a lot of knowledge when it comes to everything having to do with U.S. visas. Today, in particular, we are focusing on the President Trump's proclamation, the latest one that has come out, and what kind of effect it has on people. So I think we're waiting for some people to join. So we'll give it another 30 seconds or so before getting right into it. Just to give you a little bit of a background. Nearton Associates and Visa Place, it's an organization that's been around for over 22 years. We handle U.S. visas, Canadian visas, and we help people from all around the world. So thank you for everyone for joining us, and we hope that this session is going to be helpful in one way or another for everyone.
For sure.
So there's been a number of proclamations that have come about lately. The most recent one is the one that's causing the most sort of ripple effect for people that are affected more so. And so this proclamation went into effect last Wednesday, which was June 24th. It went in effect at 12:01 a.m., so just past midnight. And it's going to remain in effect until December 31st, 2020, so until the end of the year. It may be extended where warranted. We don't know what's going to happen at this point. The purpose of this proclamation was it's really to save U.S. jobs. It was put into effect to assist with the rising unemployment rate due to the coronavirus, COVID-19. And it's going to have a it's going to have some dire effects for certain people, unfortunately. But again, hopefully there are workarounds for those that are affected. And I just want to get into the just some of the language for this proclamation. I'm not going to read too much of the actual proclamation itself, but just the most relevant part. And so it talks about the suspension and limitation on entry. So the entry into the United States of any alien seeking entry pursuant to any of the following non-immigrant visas is hereby suspended and limited, subject to Section 3 of the proclamation. Okay, so an H-1B or H-2B visa and any alien accompanying or following to join such alien, a J visa to the extent that the alien is participating in an intern, trainee, teacher, camp counselor, au pair, or summer work travel program, and any alien accompanying or following to join such alien, and an L visa and any alien accompanying or following to join such alien. So as you can imagine, over the past week, we've fielded a lot of questions. There's a lot of uncertainty out there, and so we had gathered some of the most frequently asked questions and are going to, hopefully answer them to the best of our abilities. Starting with the first one that's come up most often, how does this latest proclamation affect Canadians? Danielle, you want to take this on?
Sure. So it's a hot topic, and there's a lot of questions with regards to that. So as the proclamation states, those who are not in possession of non-immigrant visas are subject to this. Canadian citizens are exempt from visa entry requirements on entry to the U.S. So therefore, Canadians are not impacted by this proclamation. So there is some light to the proclamation for Canadian citizens. However, Canadian lawful permanent residents or permanent residents are subject to this proclamation in that they do require a visa stamp under the particular H-1B or L-1 category on entry into the U.S. Unfortunately, permanent residents of Canada are subject to visa requirements and therefore are impacted by this proclamation.
Very good. Thank you, Danielle. And just keeping in mind again that there are only certain visa types that are mentioned in the proclamation. The one that affects most people is the H-1Bs and the L-1s, realistically.
Right.
So there's a whole alphabet soup of different visas that are available out there. Okay, so from that question, and what about in terms of the visa waiver program countries, and that's when you look at the ESTA countries that don't necessarily need a visa to enter the U.S. as a business or pleasure visitor. With respect to that, although these individuals would not normally require a visa to enter as a pleasure visitor or business visitor, they do require the actual visa stamping for L1s, H1s, etc. So it would affect individuals from those countries.
Right. And to kind of just roll back for a quick second, those essentially the proclamation is geared, or it will impact those who do require the visa stamps from the consulate in order to get back into the U.S. So as Fadi, you mentioned, those who are traveling under the ESTA, you cannot file an extension of status from the ESTA. And likewise, it's only pursuant to limited activities. So those who are looking for the H-1B or the L-1, that's work related and therefore will require a visa, regardless if you're from the country that's listed under the visa waiver program.
Very good. Thanks, Danielle. All right.
Yeah. And I guess to talk about, those who already have the approved visa stamps, does this proclamation impact those who are already in possession of that visa stamp? So again, to shed some light there, those who are already in possession of the valid visa stamp prior to when this proclamation became into effect, you are not impacted by this. It's not like your visa is going to be canceled under this order. You're safe. You're good to go with the travel, so long as your visa stamp is in fact valid under the H1 or L1B categories.
Very good. Speaking of visa stamping and so forth, those that have, there's a question: what happens to my spouse abroad that's been awaiting an H4 visa stamp? Does this proclamation affect dependents? Unfortunately, it does. So unless the individual already has a visa along with visa stamping, that individual would be able to enter the U.S. If they don't have the visa stamping, essentially anything that's affected, anything which the individual has to go to the U.S. consulate abroad for, that's going to be where the issues lie. So there might be some possible workarounds for individuals in this scenario. For example, when the consulates eventually open for interviews, if the individual does not already have maybe a B1, B2 visa, perhaps going in on a B1, B2 visa and then looking at changing status from within the U.S., that might be a possible workaround. Although all of these types of sort of maneuvering is going to be subject to discretion from the officer, whether it's the officer at the consulate abroad or the CBP officer admitting the person into the U.S. So there's sort of there's two areas of friction that the person is going to have to overcome.
Of course, and that also works both ways. Likewise, if you're the spouse under H4 in the United States and your spouse who is the primary H-1B holder who is abroad, unfortunately, it shares the same impact. Again, it comes down to whether the visa stamp is in fact valid at the time of entry. So it works both ways in the H4 and the H-1B context. Again, for those who are H-4 Canadians, you are not impacted. I get this question a lot. I think there's just a lot of nervousness crossing the border these days and traveling. There's a lot of questions. On that note, H-4 Canadians are not impacted by this.
All right, great. All right, and so you've already, so what about those that already have an approved H1, L1 visas? You already touched on that, Danielle. Anything else you want to add there?
Well, again, it comes down to whether you have a valid visa stamp. So if you are in possession of that valid visa stamp, there is no concern with regards to how this proclamation will affect you. We're going to talk later on about perhaps, the options of changing status and extending status within the U.S. If you have it expired or you don't have a visa stamp at that point, we will have that conversation later on. But again, if you have the approved visa stamp, the proclamation does specifically state that those who are in possession or who are not in possession of the non-immigrant visa stamp is impacted. Those who already have the visa stamp, you are safe.
All right, great. And there are some listed exceptions within the proclamation itself.
Right. So there's a few exceptions. I think the two obvious ones is if you're a United States citizen, this doesn't impact you. Likewise, if you're a lawful permanent resident or green card holder of the United States, this doesn't impact you. Those who are, in a very specific occupation, more closely related to food supply chain, or in an occupation that may be considered or viewed of national interest, there are arguments to be made to support the fact that these individuals hold occupations or a particular skill set that would be of benefit or of national importance or of national interest. The threshold of national interest usually requires someone who has exceptional knowledge or an advanced degree in various occupations such as the arts, science, or business. That's an exception under the proclamation, and we would have to assess the circumstances very closely and carefully to determine whether an argument can be made under those particular exceptions. And I think, Fadi, we discussed yesterday, there was a good example. If you are a business professional working on a particular project in the United States, or you have to enter the United States to pursue a particular project, and you have a very advanced knowledge or a particular skill set, an argument can be made that project, if that project is suitable or considered of national interest, that might be a scenario where you would fall under the national interest exception of this proclamation.
Exactly. So like maybe there's a project that's being worked on and it's going to be stalled without a certain individual that's able to go in
Right.
and do, the work under that project. Then that might be, and then it has cascading effects. That might be a good reason to say that it is of national interest for
Right.
this to proceed with. Very good. All right. Okay. So yeah, go ahead.
No, I was just gonna ask. We're getting a lot of questions now about what are our options moving forward. What are some pathways that we can discuss and explore? And I know there's a few that we can kind of break down and discuss at this point.
Right, for sure. So, for anyone that is affected by this proclamation, there might be other ways to sort of get around this. The particular visas I would look to is an E1, E2, and I'll get into a little bit of the details of these afterwards. But there's an E1, E2, TN, E3, H3 trainee visa, and a B1 in lieu of an H1B and an O1. So the E1 itself is it's a type of visa. It's for a treaty trader visa. So let's say maybe you're currently working for a company that's abroad, and that company does the substantial international business with the U.S. That person may qualify if they share the same nationality as the owner of the company, or owners of the company may qualify for an E1. Similarly, there's something called an E2, which is a treaty investor visa. So if a person is a part of a treaty country, national of a treaty country, and the owners have invested heavily into U.S. infrastructure, manufacturing product, whatever it may be, that person may qualify for an E2. So I'll give you an example. Let's say I work for a German company, and the German company has a subsidiary in the U.S., and they want me to transfer to the U.S. company, but now there's L1 that's in effect, and that's going to cause an issue here. So under that example, the German national would be able to perhaps apply for an E2 visa, and then get around this whole L1 being banned for the upcoming months, and still be able to enter the U.S. and do the work that needs to be done. Then again, I mentioned TN. So although this proclamation doesn't really affect Canadians, it's a popular question that comes up. Can I still get a TN? Yes, you can still get a TN. And for individuals like from Mexico, for example, where a Mexican national would have to qualify for an L1 visa, they do have to qualify for an H1B visa, whereas a Canadian does not need to. So the TN visa for a Mexican national might also be a suitable alternative for one of these other categories. The E3 is very similar to an H-1B, but it's simply put, it's for Australian citizens. So if you qualify, generally speaking, for an H-1B as an Australian, well, you're in luck. You can qualify for an E3 if the job you're looking to do is a specialized occupation. The H3 is an interesting one. So we know that the J1 is impacted here. The H3 is not often used category. It is a trainee visa type. So when you need to have the U.S. company essentially put together a training plan, and the type of training that the foreign national is going to be receiving is one that is not available in the home country. So might be some creative ways to use that. B1 in lieu of an H1B. That's also a category which I believe is going to be used more often for the next few months, because that's essentially when a person is working for a foreign company and they need to do some project work in the US. It could be a related company, may not be, but they do have to remain on the foreign payroll. So if we think about this in comparison to, say, an L1, with the L1, it is an intercompany transfer. We have to show the relationship between the two companies, whereas with the H1, with the B1 in lieu of an H1B, we don't necessarily have to get into those nuances, although we do have to show that the individual is continuing to work abroad and is going into the U.S. normally for 6 months or less. And again, it is project-based, but it does allow for some work to be done in the U.S. Then the last one I'll speak about is an O1. And an O1 is for, it can be in almost any category. It is for individuals that are, they have extraordinary ability within their field of what they're doing. So if you have you might have a business leader that was going to be transferred on an L1, but now is not able to. Perhaps if that business leader has enough accolades, we could qualify that individual for an O1. And the nice thing about the O1 is that there's no cap, unlike with the H1B. So those are probably the ones, those are probably the categories that I would look to as possible alternatives.
Right. And just to kind of touch briefly on that, all of these suggestions are there's a requirement of obtaining a visa. Now, earlier we said if you have to go through the consulate to obtain a visa, you're likely impacted, but that's only in the situation where you're applying for an H or an L or a J or H2B. So in particular with the B1 in lieu of H1B, just to touch on that, the process is very similar on obtaining a B1, B2 visitor visa at the consulate. It's very important that if you are going down the route of applying for B1 in lieu of H1B, that not only are you providing the documents to support that request, you do have to make it very clear and that you request an annotation on your visa stamp specifically for it to state B1 in lieu of H1. This is a common error that happens because they don't differentiate between the B1 versus the B1 in lieu of H1B. So I think that's just very important to note that it is going to be a popular category as a workaround with this. So just make sure that you're aware that you must differentiate between the B1 and then a B1 in lieu of H1B.
Very good. Thank you, Danielle. What about the option? I know we touched on this before. What happens if somebody entered the U.S. on a B1 or B2 and they're already in the U.S. And now the company wants to apply for a change of status to an L1, or if they already had an H1B that's been approved, maybe an H1B or one of these other affected visa types?
Right. So I think this is going to be a common question. And if you're already in the United States and you have a pending H-1B or an L-1, I'll talk particularly about the H-1B at this moment, is if you have a pending H-1B and you're already in the United States, I think you have to proactively identify how that petition was filed. There's typically two ways of filing it. being either a consular notification or an extension of status from within the US. You have to identify if the case was in fact filed as a consular notification. If it was a consular notification, what that means is you'll be granted an approval notice and you would have to essentially leave the US, obtain a visa stamp in order to be readmitted under the H-1B category. If that is the case, you are absolutely impacted by this proclamation. So you have to be proactive to determine how that case was filed. Now, if that is the case and your petition was filed as a consular notification, it is suggested likely to file an amendment through premium process to request an extension of status to prevent you from having to travel outside of the country and re-enter with a visa stamp because you won't be able to. So, again, look at the case and look how you filed it. If it was a consular notification, it's best to change it over to an extension of status that will prevent you from having to leave. The extension of status will just be extended from within the United States. Likewise, the same can be said with the L1. If you're B1 and you're in the US and you now have an offer for an L1, file it as an extension of status. Don't file it as a consular notification, only because you're kind of shooting yourself in the foot if you do that. So just that's the difference between the extension of status and the change of status, if you will.
All right, but what about, so if I'm in the U.S. on a B1, B2, and I do qualify under one of these underlying categories. Let's say I qualify for an L1. Can I start a new application from within the U.S. on that L1?
So if you're in the U.S. as a B1, B2, and you want to file an L1?
Yeah, so it's going to be like a, does this proclamation affect that, right? It hasn't been, nothing's been filed from before. Because this question,
I would say no. It does come up, but the answer would be no, is because if you're already in the United States, excuse me, there's no requirement of obtaining a visa if you're already in the U.S. So you would file the petition as a change of status from that of a B1, B2 to an L1. And that's how you would essentially change your status from within the U.S.
Exactly. Yeah. Right. So, and that brings me to the point of everyone has to be, if they are trying to enter the U.S. on a B1, B2 for the whole purpose of changing their status from within the U.S. I think that CBP officers are going to be kind of aware of this happening.
Right.
And the individual has to be careful that they're not misrepresenting themselves. Right. So they can't just say, I'm coming into the U.S. because I want to visit the Grand Canyon, knowing full well that they have an itinerary to, change their status from within the U.S. It's probably, it's in a case like that, it's getting some legal assistance with the application is probably advisable because you don't want to do anything that's going to cause any sort of, further dire consequences for yourself. And this is beyond the scope of this proclamation, right?
Of course, it's going to be tricky, obviously, and it is suggested that you speak with, contact our office and ask the questions, because it does require a full assessment and to determine whether that's the appropriate pathway. Like you said, Fadi, you don't want to be in a situation where you present yourself at the border and there's questions of misrepresentation with regards to your intent. So that's where it becomes a bit gray, and it does require a full assessment and a conversation to determine whether that's the most appropriate route or not.
Okay, perfect. Thank you, Danielle. We'll take a look now at some of the questions that have been asked that's been asked during this event. Hi, this one's not relevant to this proclamation necessarily, but hi, I've applied for an extension for B1 visa for my dad. I have a case number, but I cannot get any further details. What should I do at this point? These extension of status applications are taking a long time. Okay, so if you're if you don't get a sort of final response on on the decision, and if it takes over 6 months, that's not unheard of. So while that extension is in status, your father would in fact have almost like an implied status to be there for that period of time. But I would just be careful not to overstay, so to speak. So if we're asking for example, for a 6-month extension, I would make sure that your father is out before that 6 months. Okay, just um, in case there's if it comes back negatively, and then having to go back and prove that you took the proper steps to try to keep your father legal. So and there is no automatic bar for anyone that's overstayed in the U.S. for 6 months or less. Although it's not legal, but I'm saying that it's not an automatic. It's not part of that.
You haven't triggered the bar, yeah.
Correct.
Right.
Okay. Do I need to wait for a decision? Can I fly according to the fly dates? I'm not certain what that question is trying to ask.
I think the most appropriate response to that is, do I need to wait for a decision, or can I fly according to the fly dates? If you are flying and you need to get back in and don't have the appropriate visa to do so, it is a bit risky at this point. I don't know if it's specific to a particular visa category, but again, as long as you have a valid visa upon re-entry, that's how it relates to this proclamation and how it impacts those.
Right.
Yeah.
What about F2A? I am a Canadian citizen and my husband's a green card holder. Does this affect our case? This particular proclamation does not affect your case, but there is a previous proclamation that does. To answer this question appropriately, I think we need to have maybe a separate private conversation because the timing of when the application is filed and how it's affected by a proclamation, we can get into those details, I think, through a separate conversation.
Right.
And how long does it normally take from permanent residency till citizenship, which is coming through parental sponsorship? Again, I think that's something that's probably better off having a different conversation. It's not what we're speaking about today, and there could be various aspects of your case that can determine how long it's going to actually take. So I think that might be it for now. All right. So yes, I think thank you, Danielle, for joining me today in this event. You're always so informative these subject matters, and thank you all for joining us. If you have some further questions and we didn't touch on it during this live event, then please reach out to our office and perhaps we can again book a meeting so we can talk privately and talk more with respect to your own situation.
Yes.
Right? And for those that you've been asking some questions in relation to Canadian immigration, you can always contact our office, and we do have a number of professionals that work with us that deal particularly with Canadian immigration matters. I personally do not, neither does Danielle.
Yeah.
All right, very good.
On that note, yes, thank you, Fadi, for having me. This was very good. Hopefully we were able to answer all of the questions. Of course, as Fadi said, if you have any other questions or concerns, be sure to contact our office. There's a lot of nuances and discussions need to be had to determine the best route for you. So of course, contact us at any time.
Very good. Thank you, Danielle. Thanks, everyone.
Thank you. Bye-bye.